Hello friends, we are discussing answer writing for law main optional in civil service and other competitive examination. I am Rohit Vadhwana, Indian Foreign Service Officer. I cleared UPSC with law as my optional in 2009-10 and I used to teach law and other subjects of general studies before joining the civil services. I am taking you through the journey as how to draft a very good answer for law optional which gives you good marks. First is the structure of your answer. The structure of your answer starts with introduction. The introduction takes around 10% of your answer, where you are introducing what you are going to prove in your main body of the answer. Introduction is not just the repetition of what is written in the question, but it builds up your argument, and these arguments are developed in the main part, which should comprise around 80% of your answer. And then comes the conclusion, where you are winding up all the arguments and giving reiteration of what you have told till now. This conclusion is also neither repetition of what you told earlier in your main part or introduction, nor the repetition of the sentence and rewriting of the sentence which was said in the question. So questions should neither repeat it in introduction nor in conclusion. You should use different words but draw to the proving of your question. With this structure, good introduction, good conclusion, and enough facts and figures and knowledge in the main part, you will be able to draft good answer. While writing the answer, you should keep into mind that your writing should be larger in size, so the examiner, who is generally or is expected to or supposed to be somewhere in his 50s or 60s due to his experience and expertise in particular subject, we expect the comfort level, or we give them the comfort in writing, in reading your writings. It should not be a difficulty for him, otherwise it brings less mark for you also. It should be very clear. It should be clear in the sense, don't cut out, write and cut out, and then write and wipe out. Don't do this. Make it clear and neat. Be sure that you are giving enough space between two words, two lines and two paragraphs, so the writing is spacious enough to be legible. And this legibility is very important. I am not saying that you should write now very beautifully. Your writing skill is enough if it is legible, it is readable. You may not or may be good in beautiful writing, but perhaps that is not required because of the time and other limitations of the examination. You just try to make it legible, spacious and clear writing. You must have read a lot for appearing in this examination, but what is the use of that knowledge if it doesn't come out in your answer? Therefore, all important facts and figures that you know should be written in the answers wherever they are relevant. The supporting words which prove your argument should be used judiciously and according to their meaning. There are some technical words in law, there are some legal language and phrases that you should use for your answers. General words perhaps are not giving good impression to the examiner while writing the answer of law. So use legal and technical words as and when required. Use definitions. Definitions will be useful in law of torts and perhaps international law, but when we say definition, it also includes sections and articles language while writing the answer for constitution, IPC, contract or any other act where it has provisions. So definitions and provisions language can be used, numbers can be used, so that the answer becomes full of your knowledge. Case study. Give enough cases as and when required to prove your legal point. Give enough case and law so that the answer becomes full of relevant facts. News. If the topic is in news currently, then you may not elaborately put the news or the debate, but at least point out in your answer so that it appears that you have read it and you are aware of the current scenario and development in that particular law. So keep reading news, updated case laws, and new developments to make your answer better. Language. What kind of language we should use for law optional and their answer writing? First, whenever you write any answer, your sentences should be short. My advice is don't use more than 10 to 12 words in any sentence unless it is a definition or direct provision. Make use of simple sentences. Don't use complex and compound sentence, because longer sentence and compound or complex sentences are not that easy to understand. While examiner reads your answer, if the sentence runs into 4-5 lines, perhaps he misses the link and he has to reread it. In that case, it will be difficult for him to grasp what you want to say, and it will be your loss. Use always perfect word, like ordinance is always promulgated. When president forgives someone, some culprit, some accused person, it is clemency, not forgiveness. So use such perfect words in law. This is technical and legal language related words. Use always meaningful and easy language. Don't try to make it very flowery and poetic language. Just make it legal, crisp, and meaningful language. Make the writing lucid. Lucid in the sense the flow should be good. When you start a point, end it. Don't introduce new point without ending the first point. So it should not be bumpy ride for the reader. It should be very smooth in understanding and reading. Make it precise. Precise in the sense that only required number of words, required sentences and phrases. Don't make it very lengthy. Don't make it very unmeaningful. Presentation. Presentation means when someone sees your answer, not reads, but just sees the page in which you have written your answer. How does it appear? That is your presentation. Give enough paragraphs so it looks beautiful. It's giving a paragraph shows that you have introduced new points, and paragraph should not be more than 5 or 6 lines. Running one paragraph into one page is not a good idea. So every paragraph should have new point, and every new point should be given in new paragraph. Capital letters and italic letters should be used judiciously and liberally. Writing the name of judge should be in capital. Sometimes you can write in some important phrase in italics letters. The case name of the case or justice or thinker can also be written in either capital or italic letters to draw the attention. Sometimes even the important phrase can be written in capital or italic letters, so the attention is drawn towards that. For the same purpose, you can also use underline, but some students have habit of underlining almost half or more than half of the page. Then it becomes difficult for the examiner to understand whether the underlined portion is more important or the non-underlined portion. So keep it limited to 10 to 15% in any page. So maximum 15% of the page can be underlined or should be underlined. Ideally it should be 10%, because if the whole page is underlined, it lost its meaning. Give enough space. Enough space here, when I say a space, it means use the space to convey meaning. Normally we write when the margin line starts, near the margin line, but sometimes some quote or some judgment or some definition, if you start at indented space, it means leave 1 inch space or 1.5 inch space from the margin line and then start writing your paragraph. So all the lines of that paragraph, if you write at 1 or 1.5 inch margin, that paragraph specially appears at the indented space. This will give a new presentation. This will give a more meaning to that particular paragraph. So use this space area to convey emphasize. New lines. Sometimes new points should be written in new lines, and it can be even bullet points or just new lines. Use half line. When you are saying something, you want to emphasize it, put a dash, leave the half line empty, In the next line, again from beneath that half space, start writing your sentence. It shows that you were saying something, you are emphasizing here, you are writing a new line from the half of the space in the new line. So this is also a technique to convey that something is very important in your presentation. Then use of case law is very essential for writing answers in law optional. While writing the case law, you are not expected to just give the situation of the case. It means what happened, how it happened. No, that is perhaps not important. And given the word limits, you don't even have luxury of writing the situation in detail. Therefore, you should mainly write the crux or conclusion of the case. Let me give you one example. If the question is related to negligence and you are describing the case where the ginger bottle had decomposed body of snail, rather than explaining that situation in detail, you can just say that in the ginger bottle beer case where the decomposed body of snail was found in the bottle, it was held that XYZ. In this way, you can just give one or one and a half sentence for explaining the situation and then directly give the conclusion to draw the attention to the to your argument. Importance of the judgment should always be highlighted. It means, why are you putting up this case here? What is the importance of this judgment to your question? Unless the case and its judgment is important for your answer, don't write it. And therefore, if you are writing, then always show the importance of that judgment in proving your answer. Chronologically correct order of writing the cases is very important. If you write cases, earlier case at the middle and the latest case in the front or somewhere, so it mixes the events, and therefore the psychological impact on the reader's mind is not that good. So always use correct chronology for writing the case, and give only and only landmark cases. Landmark cases are important, and that's why all examiner will know about those cases. If you give any case which has not got that importance in that particular law, it will perhaps be not known to the examiner. Therefore, use of and landmark cases, and this is also expected while writing of when you are writing of fundamental right and directive principles and their relations. Perhaps Keswanand Bharti comes to the mind of examiner, and that's why he would look for that case and he would expect it. If you are missing that landmark case, perhaps your answer, though good, will not give you good marks. So use landmark cases only, and analyze the case in context of your question. Analyze in such a way that it proves your point. Now, to recap, what you should keep in mind while writing the answer is the structure of the answer. Introduction, main part, main body, and conclusion should be given in appropriate manner. Writing should be legible, bigger in size, and very clear. Your knowledge should exhibit in your answer, and you should use correct legal technical language while writing, and precise language while writing the answer. Your presentation must be very nice and use enough case law and landmark case laws to prove your point. Now finally, because in law optional you are facing three kinds of questions. Question number 1 and 5 are 10 markers. They have word limit of 150 words. Then you have 15 marker and 20 markers. These two kinds of questions don't have any word limit, but given the time limit, you have to still decide how many words you will write in this. At the calculation of 10 marker question, which gives 15 words per mark, you can write 225 words for the 15 marker question and 300 words for the 20 marker question. 10% plus or minus, so keep it like 150, 250 and 300 to 330 words for your 10 marker, 15 marker and 20 marker answers. And try and develop habit of writing all your answers in this word limit, so that you do not leave any question unattempted because of time shortage. Keep practicing so your answer writing will be better. Drafting, writing and practicing is the only solution for writing better answers. Thank you.